Okay, so we're at 7:30. We're expecting, I think, a few more people just looking at the number of attendees. We'll get started maybe just with some introductions as people are trickling in. My name is Andrew, and my colleague Denise is here. We're both employment law lawyers at Nelligan Law. We primarily represent employees in these types of situations. So first of all, really sorry that you're all in this boat. I know it's not an easy week for any of you. And a lot of our job or what we do is helping people who are in the exact same situation as you're in right now. And so we thought it might be helpful for us to sort of go through at a very, very high level the information, general information that everybody in your situation should know, just to try, frankly, just to be helpful and help you navigate this situation. I know it's not easy. So what we're going to do is we have to be careful. We can't give you any legal advice. So we can't give any of you on this call information about what you specifically might be entitled to. But what we can do is give you sort of information as to what generally people are entitled to, some general experience with Shopify. We both represented Shopify employees before, and we can give you a little bit of that and help you kind of make a decision as to whether or not you need your own individual legal advice and whether or not you need to go speak to a lawyer, either with us or elsewhere, about the situation you're in. So this is going to be mostly legal information. We've kind of divided it into two parts. One, we're going to talk at you and just sort of, for lack of a better term, do employment law 101, and then give you all an opportunity to ask questions. If any of you are sort of worried about being anonymous with your questions, feel free to sign back in using, an acronym, nickname, whatever. That's fine. We're happy to still answer those questions. I know there are maybe even some existing Shopify employees who are maybe going to be attending today and want some of this information and might want to ask questions anonymously, and that's absolutely fine. If you want information specific to your situation, we'd have to do that on a separate call, and we'll talk about that a little bit at the end. But that's generally what we're going to do. So I'm going to hand it over to Denise. She's going to get started by just talking a little bit generally about what is a termination and how does that work.
Thanks, Andrew. So really the starting point that you're going to want to look at is what type of termination am I looking at? So most of you would be in the situation where you're terminated without cause. So there's, two types of terminations we typically deal with cause, without cause. With cause, essentially, you're not entitled to any termination pay. Without cause, you're entitled to termination pay, and Andrew and I are going to, go through what you're entitled to minimally, and what you could be entitled to if you don't have a contract that governs how much you're going to get paid if you lose your employment. So if you're in a situation where you have lost your employment and Shopify has done it with cause, then that's a bit of a tricky situation. You should probably get some individualized legal advice, because cause is generally it's actually notoriously very difficult to make out. So it's a very high threshold. So for most of you, and I assume it's without cause, so then you would look at, okay, I've lost my employment, therefore I'm owed under the Employment Standards Act, which are your minimum entitlements. And Andrew's going to, set out the difference between the statutory notice and statutory severance under the Employment Standards Act. So those are your minimum payments that your employer has to pay you out of without cause termination. And then if you don't have an enforceable termination provision in your contract, so your employment contract doesn't have a clause that limits your entitlements properly and validly, then you might be entitled to more than just those minimums under the Employment Standards Act. So Andrew's going to talk now a little bit about how we determine whether it's, just ESA minimums or if you're entitled to a little bit more.
Yeah, and so just to pick up from Denise, so ESA is the Employment Standards Act, and lawyers like to call the Employment Standards Act it is it is the basic rights that every single employee in Ontario gets basically no matter what. So things like minimum wage, hours of work, breaks, all those sort of fundamental rights that everybody who's working has are set out in the Employment Standards Act. And the Employment Standards Act also speaks to what people get in a without cause termination, which 99.99% of you should be in that boat. And frankly, if Shopify was alleging cause in a mass termination, it would be pretty suspicious, and I'm not sure a court would buy it in a situation like this anyways. But all that's to say is the Employment Standards Act sets out two sort of types of money that you're entitled to when you've been fired without cause. The first is termination pay, and the second is severance. Those are, generally what everybody is entitled to no matter what. Even if you have a new job a couple days from now, you get those two amounts. So the termination pay is fairly easy to calculate. It's a week per year of service. So if you've been there for 4 years, you get 4 weeks. If you've been there for 12 years, you get 8 weeks. It maxes out at 8 weeks, but it's a week per year of service. The second amount is severance pay. And severance pay is a week per year of service up to a maximum of 26 weeks. So again, if you were there for 4 years, you get, actually, sorry, I should take a step back. You have to have worked for a minimum of 5 years to be entitled to severance pay. So if you've only been there for 2, 3, 4 years, you don't get any severance pay. If you've been there for 5, you get 5 weeks. If you've been there for 12 years, you get 12 weeks. And it maxes out at 26. So that's the first two things. And if I had to bet, your termination letter says something along the lines of a unconditional amount of money that you're going to get, and it's going to be those amounts. It's going to be your termination pay and your severance pay, because courts have actually said it is bad faith for employers to not automatically pay those when they're letting somebody go in a without cause situation. So my guess is every single one of you on this call has gotten those two amounts, and so you should probably check, have they calculated that properly? Is it the week per year for termination and the week per year of severance? There is also a section in the Employment Standards Act that speaks to group terminations. And I do understand from some of the comments we've gotten from people, there may be a little bit of an understanding of this already from some of you that, oh, I'm entitled to a minimum of 16 weeks. And I believe the CEO of Shopify actually maybe sent an email or sent something around to everyone saying everybody's getting a minimum of 16 weeks. And what I think has led to that is the group termination clause of the Employment Standards Act that says if an employer lets go more than 500 employees within a 4-week period of time, everybody is entitled to a minimum of 16 weeks of termination pay. I've been kind of digging into this a little bit today and looking at the language that Shopify has been using. And I am not sure whether or not this qualifies as a group termination, because there is an exception in the Employment Standards Act that says it has to be at least 10% of the workforce. So even if it is more than 500 employees, it also has to be more than 10%. And I know Shopify has said 10% in all its communications, but a lot of them I've been parsing through and they say around 10%, about 10%. And knowing the quality of the legal advice that they tend to get, if I had to bet, they are a few employees short of 10%. They have probably intentionally ensured that they're not triggering that extra amount of termination pay you'd all be entitled to, which is why my understanding is most of you, for the unconditional amount, have not been given that automatic 16 weeks of termination pay. Because just to be clear, it would be 16 weeks of termination pay plus your severance entitlement. So if you'd been there for 10 years, you would get 16 weeks plus 10 weeks of severance. And I don't think people are getting that. And it is probably because they kept under the 10% threshold. My understanding is also they may have let people go about a month or two ago. You don't get to count those people because it has to be within 4 weeks. So if Shopify were to do this again more than 4 weeks from now, you'd be in the same boat. I see a couple questions just about Quebec lawyers. We actually do have some, just I'm going to the chat quickly because I saw them popping up. Employment standards in Quebec are different. We do have lawyers at our firm who do Quebec law. And if there actually are enough of you who are interested, we might be able to do like a shorter version like this that sort of kind of clarify some of the Quebec related stuff. So maybe after this, if you can send me a message or an email, and we can, we might be able to do something similar, or if it's just a few of you, we can put you in touch with lawyers who practice in Quebec. Keeping in mind that if you were working in Ontario but living in Quebec, Ontario law would apply to you in all likelihood, although it may differ. So to take a step back, Employment Standards Act, all of you get no matter what. The second of the three types of damages you would get is your contractual amounts. So that's what's in your employment contract. And I've reviewed a lot of Shopify contracts over the years, and generally they have a formula in them that says you get your Employment Standards Act amounts plus a certain number of weeks per year of completed service. That's my understanding. You may not all have that. And so also if you're talking to each other about what you've been offered or what you're getting and it's different, that's probably one of the reasons is your employment contracts may be different. And also you shouldn't probably share what you're being offered because that could throw off some settlement stuff, but we'll talk about that at the end. But all that's to say is the next amount you get is what's in your contract, and would be that set formula that says, you know, I get a week or I get 2 weeks per year of service or whatever it says. It may say a month. If you were able to negotiate something when you started, it's going to depend on your own specific circumstances. Another aspect of this is even if you start a job tomorrow, even if you get a new job, you get to keep that. You are still entitled to that amount. There is a case from about 10 years ago that said that if there is a clause in a contract that says you're entitled to a certain amount, you get that amount, even if you find new work. So, you know, you get that. Another thing I have seen in Shopify contracts that is really important is a clause that speaks to what you get if Shopify terminates you for cause, which is doing bad things. In the last couple of years, the case law around that has changed. And it has actually arguably meant that people who signed their Shopify contracts 2 to 3 years ago or further back likely have a clause in their contract that makes actually the entire contract illegal. And entitles you to get more than what's in the contract potentially, and we'll talk about that, but what's called common law notice. So again, this is one of those things that you probably need to get your own advice on, especially if you have an older contract, but even maybe a newer one, because I don't know when they made this change. But there is a clause in the Shopify contract that is arguably now offside because of this recent case law. That would mean you could either A, say you want your contractual amounts because maybe that's to your benefit, or B, say, actually, the contract's illegal and I get common law. And common law is the third type of damages that people are entitled to. And so common law is just lawyer speak for judge-made law. And it is what judges have said people get when they're fired. And what judges have said is it depends. It depends on your age. It depends on your years of service. It depends on how senior you are. It depends on the economy and how easy it's going to be for you to get new work. Were you a new hire, but you were recruited away from another tech company that you'd been at for 12 years and they very actively pursued you and then let you go a couple months later? Things like that affect how much you're entitled to, but roughly it's a month per year of service. Judges like to say there's no formula and then somehow magically end up at roughly a month per year of service, but it does get adjusted up or down based on your age. Do you have a disability that requires accommodation that might make it harder for you to find a new job? Things like that adjusts it up or down. Now, the biggest thing about the common law notice period, because often I get people saying, oh, this is great. I've been there for 10 years. Under the ESA, I'd only get 20 weeks or 18 weeks. But at common law, you're telling me I get 10 months. That's fantastic. It's got a big caveat, which is called the duty to mitigate. And duty to mitigate is just lawyer speak for your obligation to find new work. So Denise is going to talk a little bit about that, but just know that you don't just get 10 months if you've been there for 10 years. There's actually a big clawback because of the duty to mitigate, which Denise is going to talk about.
So yeah, as Andrew mentioned, like the duty to mitigate is essentially a credit that Shopify would get if you find new employment during the reasonable notice period. So let me break that down. So say that you are entitled to 10 months of reasonable notice from Shopify, and that's worth $100,000. Well, if you find new work that pays the same at month 6, then Shopify gets a credit for that 6 months where you were able to mitigate your losses to find new work and get paid, roughly the same amount. that means that your, $100,000 claim has now just, gone to $50,000. Because what you have to do is you have to go out there during your reasonable notice period. So again, our example of 10 months, and try to find comparable work. So it's a positive obligation that you have if you're let go, where you have to go and try to and make efforts to find something that's comparable. So I'm putting the emphasis on the word comparable because you don't have an obligation, to just take on any work. What you have an obligation is to take on something that was, similar to the position that you lost at Shopify. And the example that I like to give is if you're offered new employment, but it pays half of what you were, earning at Shopify, then that may not be comparable. So you have to think, really carefully before you accept or you reject new employment, because you have to make this analysis of whether or not you have an obligation to accept a new offer. So the other item that's an important thing to just bear in mind is that if you fail in your duty to mitigate, so if you, for example, you've lost your employment and then you do nothing to try to find new work, then the employer can be entitled to a credit for your failure to mitigate your losses. So what you want to do to show that you've taken all the steps that you're required to take is you want to just, keep a record. So keep, even a notebook of all the, the coffee chats or the LinkedIn messages or any job applications or anything like that to clearly show if you need to, show that you've discharged your duty to mitigate, to just show that you've done everything that you were required to do at law to find new work. So that's essentially, the duty to mitigate that applies to reasonable notice. So the judgment law that Andrew was just talking about. But when it comes to those minimum entitlements, so under the Employment Standards Act, there's no such, clawback for those minimum entitlements. It applies to your reasonable notice period.
And just before Denise is going to continue, I sort of just want to take a step back because I forgot to mention something. In terms of being entitled to common law, not all of you are going to be entitled to common law. So one is if you have an enforceable employment contract. So if you signed a new employment contract in the last couple of years, it's possible that Shopify has fixed that, for lack of a better word, loophole that existed in their earlier contracts. You may not be entitled to common law. But if you have no employment contract or you signed one, on day one and it didn't say anything about what you're entitled to on termination, because I can't remember if really early Shopify employees had anything in their contract, because often people don't. Frankly, a lot of the people we see just don't have an employment contract or don't have an employment contract that says anything about termination. Those people are automatically entitled to common law. And then the other thing is just a lot of what we do, or a lot of the opinions that we give to people, are looking at termination clauses to say, yes, this is enforceable, or no, it's not. So you do, again, it very much depends. It's very context specific. There are times where people have enforceable employment contracts, but it was given to them, within the last year, and they weren't given anything in exchange for it, and maybe there's an argument that it's actually not enforceable for that reason, and they're entitled to common law. So it really depends on what your situation was and how that contract came to be. But I just want to be clear that some people are entitled to common law, some people aren't.
Yeah, that's a good point, and a really common comment that clients make is, well, I don't know where my employment contract is. I had, signed that thing 5 years ago. That's something that you could easily ask for. Like just ask a copy from HR to get a copy of your employment contract. That's completely normal. Because again, you need to determine, that termination clause, which is that clause that determines how much you're entitled to. If you lose your employment, that's going to govern what you're entitled to. If it's just minimums, if it's common law. And like Andrew pointed out, common law, although there's no hard and fast rule about it being 1 month per year of service. If it's 1 month per year of service generally versus your minimum entitlements, which is a question of weeks, then that's a huge difference. So moving on to, if you're entitled to common law reasonable notice, so the judge made law, what does your employer have to continue during that period? So, say you're entitled to, we'll go back to the example of like the 12 months, so 12 months of reasonable notice. What does your employer have to pay out? And the law says that the employer has to continue all terms and conditions of your remuneration throughout the reasonable notice period. So this includes things like obviously your base pay, your benefits, so STD, LTD, dental health benefits. If you had some kind of a incentive or bonus plan, you're generally entitled to get that incentive or bonus if you would have gotten it, but for your termination. So if, during that 12-month reasonable notice period, you would have seen yourself getting a bonus, if you would have still been employed with Shopify, then the way that the law works is that you're entitled to that, subject to any plan or like an annual incentive or a bonus plan that tries to limit that right. So that's something that you want to keep in mind. And again, another reason to get that individualized legal advice, because sometimes those bonuses are worth quite a bit. You don't want to miss out on that. So that's another document that would be a good idea to just dig up and get a copy of, is if you have a bonus plan or an incentive plan, anything like that. So I mentioned that your health benefits have to be continued throughout your reasonable notice period, and that's particularly important if you're struggling with a health issue, if you need access to short-term disability or maybe even long-term disability down the line. That's something that your employer has to continue throughout your reasonable notice period. So if you're having health issues, that's something that you want to be alive to, is, okay, do I need access to these types of benefits? And ask yourself those questions to make sure that you're protecting your access to those important benefits. I understand that Shopify has some shares that they offer to their employees. Those are a little bit different than an incentive. So an incentive, as I mentioned, or a bonus, you're entitled to that, but for the loss of your employment. Shares are a little bit different because it depends on when they vest. So they're kind of a different analysis than every other term and condition of your pay. But generally speaking, if you're entitled to 12 months of reasonable notice, your employer has to continue all of the aspects of your pay during those 12 months. Another thing that you'll want to consider is, and it kind of ties into that access for health benefits, is if you've had any kind of, issues at work, like if you filed a harassment complaint, or if you needed accommodation for whatever reason, or if you've had anything kind of within that vein, you want to pay careful attention to, whether or not it'd be best to get some individualized legal advice, because typically when we're talking about, accommodations, or if you just came back from a parental leave, for example, and then you've just been let go, those are kind of factors that kind of make things a little bit more complicated, in the sense that we're no longer just looking at the case from the lens of what are your termination entitlements pursuant to the ESA and the common law, but there might be other kinds of damages, other pay that you're entitled to for, say the breach of a human rights code, or if there was some kind of bad faith or anything like that, that was involved in your particular situation. So it's always a good idea to, if again, going back to that example, if you had accommodations, or if you just came back from a leave or anything like that, or filed a harassment complaint, that complicates things. So it's always a good idea to go talk to a lawyer about that.
Yeah, and just to sort of unpack that too, the part of the reason is you're possibly entitled to additional damages. So there is an obligation on termination to act in good faith, as well as just generally not to discriminate. And so what I've seen before, especially in sort of larger scale terminations, is sometimes employers try and capture some people they are maybe trying to get rid of, or have been trying to get rid of, in the group, to try and give themselves some non-discriminatory cover of, we were accommodating this person, we didn't like how the accommodation was going for their disability, and so we're going to get rid of them now, but use the cover of the mass termination to disguise what is actually discriminatory behavior. So that may be bad faith. And, generally there's a different type of damages you may be entitled to. But again, like that is a huge, it depends. We need to know a lot of specific information to go there. I also I see questions kind of coming up on the Q&A. I'm just going to leave them and park them for now and sort of circle back to them in a second. But I did want to sort of take a step back to some of the stuff about salary with the incentive pay too, because there's the fact that it continues as though, through the notice period, you're entitled to it as you would have been. But one thing, especially if any of you are in sales or in a group where your income tends to vary significantly year over year, or your base comp is incredibly low because you have significant incentive comp, there are cases that have gone back and in calculating what you're entitled to in your notice period, we'll use averaging or sort of tricks like that to try and calculate what your damages are through the notice period. So, if you made 200 grand last year, 100 grand the year before, and 300 grand the year before that, a court may just say, look, we're gonna credit you as $200,000 a year in salary to deal with the fluctuations year over year. But again, it's, we're gonna say it depends a lot. That is the lawyer's answer, but this is where we're kind of getting into individual calculations. The other one that makes sometimes Shopify particularly tricky is any of you, especially early employees who have significant equity that has vested year over year over year and have some pretty significant T4s in the last few years, whether or not you can claim that as part of your income. You may be able to. It's tough to say. I haven't seen the most recent sort of equity documents and whatnot, but again, that's something to be thinking of and mindful of am I just entitled to my base salary, or should it be topped up for some of these variable amounts? So, very high level, those are the types of things that people need to be mindful of. So what do you do about that? So if you have a letter and you're looking at it and saying, okay, well, Andrew and Denise have said I'm entitled to X and this looks like Y, or I'm not sure if it's fair, what do I do about it? And in Ontario, your remedy, if an employer hasn't paid you fairly when you've been fired, is to bring what's called a wrongful dismissal action. Wrongful dismissal action is just suing them for your entitlements on termination. That's all it is. And in group situations, there's kind of a bunch of different ways you can do it. One is you just do it on your own. You either by yourself or hire a lawyer. You can bring a claim, especially Ontario has a small claims court, which has a max of $45,000. Some people will bring small claims actions against their employer on their own for that much. Or you can just, it's 35,000. I think it's supposed to go up to 45 at some point in the next year or two, but basically you can do that by yourself. Small claims is designed to allow you to do it by yourself. You can also hire your own lawyer and advance your claim on your own as well. And that's fine. And that's actually probably best for people who have specific human rights issues or equity issues or things that make them a little bit unique that might make their compensation or their entitlements a little bit tough to calculate. The other thing that some people will do is bring what's called a group action. So often what will happen is a group of employees who are in a similar circumstance because they've all been laid off or let go at the same time will jointly bring their action against their employer together, because what that does is it sort of levels the playing field a little bit. One of the biggest barriers, frankly, that employees face when they're trying to get what they're entitled to when they've been fired is their employer has a lot more resources than they do. They can hire whichever lawyer they want, and they can usually litigate against people much easier without having to worry about the money, because they're not really spending their own money, they're spending the company's money. And so by proceeding as a group, often what happens is it allows people to combine their resources. It allows for economies of scale. So, one or two lawyers or three lawyers or whatever representing a group of 10 people is going to be a lot cheaper for each of those individual people than one lawyer representing one person, because there is just going to be a lot of overlap and duplication and things like that gets dealt with. And so if at the end of the day people are not happy and they're not able to resolve their issues with their termination pay with Shopify, they can kind of band together to do that. One of the nice things that's happened in Ontario is there's been this process called summary judgment, which basically lets people get in front of a judge a lot quicker. I usually tell people if they're looking at a trial that they're thinking 3 to 5 years to get in front of a judge, which is really not great for someone who's been let go and is having to pay legal fees for 3 to 5 years to seek justice if they're not being paid fairly. What summary judgment does is it lets you get in front of a judge within a year or two, which still, every time I say that, it still sounds ridiculous that it would take a year or two, but that in the lawyer world is quick. For a lot less money. Trials cost, frankly, the hundreds of thousands of dollars. Summary judgment motions cost in the tens of thousands of dollars. So there's significant cost savings there, because what you do is it's all in writing. You file all your materials in writing, and then you go and you argue it in front of a judge. There is also the possibility of a class action, which you've probably heard about just from the news, or maybe you're even familiar or have been involved in one before, but that is where one person brings a claim on behalf of everybody who's affected. There have been some employment law class actions, and I'm even running an employment law class action right now, and I'm not sure they always make sense. You have to go through a summary, a sort of a process to tell the court that, yeah, this is okay to proceed. And it adds a lot of procedural steps that sometimes make sense, sometimes don't. And I'm not sure if it would for your group, but just know that that's another option. And it is a somewhat efficient way to advance things. But in cases like this, I'm not sure it makes sense. So what usually happens, though, before you get to that point is people negotiate, because most employment law disputes do not get to a court. Probably for every 10 clients I see and that I'm giving this type of information to, or similar advice to, maybe 2 will ever even start some kind of legal challenge. And that might even be high. Most people, what they do is they either hire us or they do it on their own, and they go back to their employer and they try and negotiate an improvement. And informally, we go back and forth with the employer and try and get to some kind of compromise that is maybe not everything you would be entitled to if you win on all your claims, but is some fraction of that, to recognize the fact that there's risk if you sue. There's the time risk, it takes years. There's the cost risk. If you lose, you could pay Shopify's costs. Even if you win, you may not get all your costs. Courts tend to only award somewhere between 60 to 90% of your costs, depending on a whole bunch of stuff. And so there's a lot of pressure built into the legal system to make everybody come to a compromise, and that means most things settle. And so, ourselves and other employment lawyers at other firms generally would do a number of things. One is they'll give you advice and say, this is what I think you're entitled to. And then the person will take that advice and they'll go back to Shopify or their employer on their own, and they'll just try and negotiate something better. And if they improve it, great. And if they don't, they'll just kind of sign off what they get and go on their way. Sometimes people will do that, but with a lawyer kind of in the background, ghostwriting their stuff. And one of the reasons you might do that is you have really good relationships that you don't want to mess with by sending a lawyer's letter, but you feel like you've been shortchanged and you do want to kind of take a kick at the can and try and do better and feel like you need a little bit of advice. So people will get sort of some background advice, some ghostwriting, some things like that without actually sending the, scary lawyer's letter. To the employer to leverage those relationships. And a lot of the time I encourage my clients to do that. It saves a bit of money. And I do think there's that sort of personal relationship that can be very helpful to getting to an outcome. It's easy to tell me no. It's a lot harder to tell someone that you've worked with for the last 5 years and, had Zoom calls and Christmas parties and all that stuff with for 5 years now. And so we can sometimes leverage that to get a better outcome. And then the other one is the scary lawyer's letter, which we call a demand letter, but is basically a letter that says, here is what this person was actually entitled to, not what was set out in their termination letter. And here is some kind of compromise offer to settle that that our client would be, happy to walk away with. If we can resolve this, usually they say, you're wrong about everything you said in your letter, and also we're never going to pay that amount of money, and then they offer an approved offer, and then usually we pick up the phone and over the course of a few months try and negotiate some kind of package. When I have been involved in sort of big terminations like this, often kind of what we'll do is we'll do a bunch of those individually, and then after 3 to 5 months, we see how many claims are left and how many weren't able to resolve, and go back to those people and say, okay, you're the remaining 10. Do you want us to let the other 10 know that you're still there and think about doing some kind of group action or something like that? I usually think that that's kind of I mean, court should be kind of the last resort because it's expensive and risky. Trying to resolve things at a cost efficient way is really better for everyone. You'll notice everything Denise and I have talked to you about, other than maybe benefits, is about money. And so part of the advice you should always be getting with respect to being let go is, this is how much it's going to cost versus this is how much you can expect to get. Because if we charge you, tens of thousands of dollars to get you tens of thousands of dollars, so it just goes to Shopify, from Shopify to us, you're not going to be happy with us. You're never going to recommend us again. And it's just, we're not giving you good service if that's the case. And so we always have to be mindful of trying to give you advice that makes sense to your situation and how much you're entitled to get, and the particular risks you have. The biggest risk every one of you has, especially if you're entitled to common law notice, is you're going to find a new job at some point. And when that happens, it may affect your legal claim pretty substantially. So we're always trying to be mindful of that and making sure that people are understand what the cost is of going forward. So, generally what people will do is either, some people will sign it back and accept it. And actually Shopify is probably hoping that most of you will sign it back. And that's usually what happens in these group situations, is they offer people somewhere between 60 and 80% of what they're probably owed. And probably most people will sign it back. But for the ones who don't, they will try and negotiate, and Shopify may or may not offer to improve that offer through negotiation. But the biggest thing, and this is going to be my bordering on legal advice, is do not sign the release if you want an improvement. So I presume that Shopify has sent you a release, which is a document that says you cannot sue us. If you sign that, there is nothing you can do to improve your offer. Short of them literally holding a gun to your head to get you to sign it, there is nothing you can do to improve your offer if you've signed that and given it back to them. So that is the biggest thing. If you're not sure, if you're on the fence, the worst thing you can do is signing it back and then coming back and thinking that you might be able to improve that offer.
Just to jump in there, Andrew. The other thing is that a lot of people think, oh, I'm getting this offer, I need to decide now. I need to decide whether or not I'm going to accept it or if I'm going to do anything about it. And, what you need to remember is that you do have some time on your side. So if you do decide to start a lawsuit, you have 2 years to do that from the date that you're terminated. So there's no pressure to make a decision, tomorrow. If you need a little bit more time to go just consider it yourself or go get legal advice or any of that. So you do have, again, 2 years from the date that you're let go to sue. So that's to bring a court action, and no pressure to accept an offer if you're really not sure about it and still on the fence.
Yeah, and just to add, the week or two or whatever deadline you've all been provided is an artificial deadline created by Shopify to make you feel like you have pressure to make a decision. You don't. Your Employment Standards Act amounts have to be paid out. And any time in which I've had clients go back to the employer and ask for more time to think about it, and they've said no, it's usually been a pretty good sign that they're being shortchanged, to be honest. It's a pressure tactic. It's to try and get people to sign on to a deal that's probably not fair. And so if they are pressuring you into signing, it's probably a good sign that you should maybe get some individual advice and look at your own situation. Because it is a completely artificial made up deadline by them. Mm-hmm. So, like I said, it generally takes people in the range of a few months to try and negotiate a better package. I do like to give people a sense of cost, and usually the cost depends. Depends on how much back and forth there is, the cost if you retain a lawyer. It depends on what level of lawyer you get. Our firm has people who have just been called to people who have been practicing longer than anybody in Ottawa. And our rates vary from, a couple hundred to 700. And, again, it depends on whether you need somebody who's at a higher level or you just need some quick advice and whatnot. But generally, to negotiate a severance package, I find it's in the range of sort of $3,000 to $6,000. It can be more, it can be less. It all depends. But I do like to give people a sense of what it would cost. But again, if you have some complicated human rights issue that has a lot of medical documents and all this, and it takes a long time for Shopify to respond, it could be a lot higher versus if you just want a slight improvement and just, want some ghostwriting help, it may just be, 1,000 or 2,000. It really, really depends on what you want and what you need. And I would expect most lawyers in Ottawa probably would be in the same range. The one thing be careful about is if anybody's trying to sell you on the idea of doing something on spec, which is, oh, you don't pay unless we get an improvement or unless we get a settlement. There's a lot of people doing that in employment law right now, and we generally don't unless there are really compelling reasons, as in the person is on Ontario Works or in receipt of sort of like income support type situations where they literally have no money, because all you're doing is you're asking that lawyer to be your bank. You're asking them to effectively loan you the money for the legal fees for maybe years, and lawyers charge more money than banks do. That's how it works. And so usually you actually end up doing worse in the end. And if you have the money to pay out of pocket, you usually spend a lot less money, because really that's all spec is. It sounds great. It sounds you're not paying until, I get an outcome, but that is because when you pay, you are paying the interest rate for the lawyer having carried your legal fees for, maybe a couple of years. So just be mindful of that. If I know a lot of people kind of jump into that boat. We really don't do it, and we don't do it for that reason, which is I think people they end up paying more, and most people can do better with their own bank. So yeah, that's generally sort of what happens in these types of situations. That is generally how employment law works in Ontario. If you do, decide that you want us or some other lawyer or whoever to look at it, the important things you're going to have to provide them is your employment contract. That's going to be the biggest thing that is going to make every one of your packages very different. Your termination letter to see what are you being entitled, so we can kind of figure out the difference. Any communications you have in writing or otherwise. Sometimes the HR person will slip you your termination letter and whisper in your ear, go get advice. Well, this is going to be improved. Sometimes they don't. Any of that kind of information you've gotten from them. And then, conflict checks too. We've been in these situations where we can only represent some people who've been let go because there's conflicts, not with Shopify, but, two people who have been let go, and the human rights issue involves two of them because there was a complaint against the other one or whatever. So there's some conflict screens we'd have to go to. And sometimes we have to refer people to other firms if there's a conflict, but we always make sure to refer you to a firm that we would go to ourselves if we were in that situation. But that's kind of generally how it works. So I think this is probably where we want to turn it over to the Q&A. I have been keeping an eye on it. I already spoke to the Quebec one. I did see in some of them that they're sort of asking borderline legal advice about specific situations. So I need to be careful about how I answer those, because I can't give you legal advice about your own situation because I haven't run a conflict check. Because and it may not even be that it's an employment law related issue. Maybe you went through a divorce or you bought a house from someone and that someone is our client. I can't give you legal advice if we happen to be representing that person. So I can give legal information. So I see a couple questions about, I was offered something weeks ago, or I was laid off weeks ago, and now people are being offered more. Am I entitled to more? And so I can't tell you specifically, are you entitled to more? What I can tell you is each one of you is entitled to what is set out in your employment contract, as Denise and I said. So the fact that they're offering people maybe more now than they were earlier doesn't really matter for legal purposes. What matters is, what does your employment contract say? How many years were you with Shopify? And, all that information. And this is where I really tell people to be very, very careful about what you hear in the rumor mill about what so-and-so got or what somebody else got, because you don't know, were they on a medical leave and it's a really messy termination, and that is why they got a bunch of extra money, is they had a human rights issue that you didn't have, and Shopify paid a little bit extra to sort of avoid them getting sued for the human rights issue. Or did they have an employment contract that they negotiated on the way in where they got 3 weeks instead of 2 weeks, or 2 weeks instead of 1 week? Because I'm pretty sure, again, I would wager a significant amount of money that in the release that you all have, and if anybody has signed the release and given it back, it contains a clause that says you will keep what you got confidential. And so if people are telling you what they got, they're breaching possibly their confidentiality agreement. and B, they may not have gotten advice, they may not have totally understood what it was. And so just take everything with a grain of salt and know that what you are entitled to is completely unique to yourself and has nothing to do with what other people have been offered. So that's the first one I saw. I see another one saying the contract says you agree, except as said in section 10, no further amounts will be noticed. Is that what we're talking about? I think that was about what is the clause in the Shopify contract that is arguably illegal. So two things. One is, no, that's not. It actually is the clause that talks about what's going to happen if you're terminated for cause. There's some recent case law that has said the language that Shopify generally used to use is maybe illegal. But two is, and this is something we see a lot, is even if Shopify uses like a precedent or a standard form contract for all of you, HR people and managers like to pencil in and pen in their own things once in a while and may even change it in other ways that makes it illegal. So again, this is kind of the like get individual advice point. But it is the clause that talks about cause that makes it illegal, as well as maybe some other things that may have happened to either recruit someone or get somebody to come on or sign on, because often people will make things outside of the control of legal or HR that renders a contract illegal. And Denise and I see those a lot, and usually get a really upset phone call from the lawyer who drafted the agreement, upset that that the manager sort of crossed out their language that would have made the contract enforceable. Denise, I'm on the question about reemployment. Did you want to hit that one?
Yeah, so the question is, are we entitled to keep the severance pay if somehow we end up re-employed with Shopify? And I think the short answer to that is yes, but it would also kind of depend if you have a clawback for any kind of mitigation. So if you sign an agreement that says, sometimes they're crafted in a way, in such a way that says, okay, we're going to pay you out X amount of months, but if you get new employment within these months, then we're just going to pay you out 50 cents on the dollar. That'd be that kind of a particularized situation that you want to pay attention to. But generally speaking, if you terminated and you've received your termination pay, and you sign a release, then you get to keep that money, subject to like any kind of weird scenario or anything like that.
Yeah, what it really affects is maybe if you were let go again afterwards, what you're entitled to at that point. Unless they rescind the termination. I have had that happen before, not often, but somebody gets fired and like we send a demand letter and then they actually respond to say, actually, we made a mistake and want that person back. And then it would be a little bit different because you can sometimes negotiate that. So the question after that is, does the employment contract become new with every role change, or are you speaking of the original join date? That's a really good question.
Yeah.
It depends. Again, I'm going to say that a lot, but there's some case law that has said, think of the person who started very junior, signed an employment contract that maybe had some very trivial amount that they're entitled to when they've been fired, and that advances to a director or a VP level 10 years later. There have been some courts that have told employers you don't get to go look at that contract that he or she signed when they joined the company, because their role has changed so much that we're not going to enforce it. But again, that's going to depend on how long it was, how much you advanced, how different the roles are. And it's also going to depend on how your original contract was drafted. The employer might have put something in there that said, even if your role changes, this continues to be in effect. But it's a really good question. The other one is I know for a fact, because I've represented Shopify people before when they've had questions about getting a new contract. Some of you may have been offered a new contract with a promotion or something like that, which may or may not be enforceable depending on how they did it. So sometimes what they'll do is they'll give you your raise, put you in the position 6 weeks after you've been working in it, ask you to sign the contract. There's an argument that contract's not enforceable because you already accepted and were doing the job. So this is why if you're in one of those boats where you have multiple contracts and stuff like that, it's good to just find out for yourself, because it's going to be different. Denise, I'll let you take the next one.
Yeah, the next question is a really good one. It's, if you're close to retirement, what happens if you're close to retirement and you won't be looking for a new job? So generally, like I was mentioning before, you do have a duty to go out there and find new work. There is some really recent case law. I think it was the Hetrick case that spoke of the duty to mitigate if you're at a certain age, but I think that the employee in that case was in his late 70s or something like that. And the court had said that depending on your age, if you're, at that stage in your life, you may not have a duty to mitigate, but the general rule is that you do. So you always want to err on the side of caution and, do what you can to try to land that new work. And the other thing that you may want to consider is if you're close to retirement, you have no intention of going and finding new work anyway. You might want to keep that in mind in terms of, when you're negotiating, if you're negotiating a package, maybe taking a little bit less than you would have been taking it if you're, younger, for example, because you just don't have an intention to go out there and find anything new.
So the next question after that one is, if the rate of pay changed during my tenure, would termination pay be calculated according to my original rate or my new rate? So generally, it's based on your rate at the time of termination, especially if your compensation is predictable and it's your base salary, and then you get some benefits and whatnot. It's usually just based on what your pay was at termination. However, there are some situations that I already talked about, like salespeople. Salespeople, their comp is really tough sometimes to calculate. It changed. It's sometimes incentive driven. It's sometimes equity driven. It's sometimes both. And I have represented salespeople that earn $1 million one year and 30 to 40,000 the next year, because the way their sales cycles work is they close deals every 2 to 3 years. And so for people like that, it can really, really vary. But for most people who are salaried, and that's where most of their compensation comes, it's based on your comp when you were fired. The other time I've seen it maybe increased is if there was a reduction in your pay recently. So I have had some cases where, a couple weeks before somebody was let go, they sort of demote them and then fire them and try and claim that lesser rate of pay. There may be some window to negotiate or argue that no, you have to base it on the higher rate of pay, but that's going to depend. So we can just keep trading off, Denise, if you want.
Yeah, so the next question there are two questions here. The first one is, can we request records of our performance reviews? Even if we get that, does it help? And I think generally when you're talking about performance, you're trying to loop in, if there was poor performance or good performance, you have that conversation if there's a termination for cause. So if there was a reason for Shopify letting you go, then you kind of want to get into the weeds there about if they're saying, well, we're letting you go because of poor performance, then obviously it's relevant to get your performance reviews and you want to, go and get into those facts. If it's a straight up termination without cause, it becomes less relevant. If you want a record of your performance reviews, if you need to litigate, you can compel those records being disclosed if you need to sue eventually. But we usually don't ask for disclosure of those types of documents if you're negotiating, because the entire point is to get a speedy resolution. And again, if it's a without cause termination, it wouldn't necessarily be relevant. So the second one is, seeing Shopify's blanket severance is marketably fair. What are the risks for opening up this conversation with Shopify? And the risk is always that beyond your statutory amounts, anytime that you're giving a counter offer, what it does is it extinguishes the current offer on the table, pardon me. So say that Shopify currently offers you, 3 months of reasonable notice, and you go back and you say, well, no, actually I'm entitled to 6. When you make that counter offer, you've just extinguished that 3-month offer that was on the table. So the technical effect of countering is that you're going back and forth, and now your new live offer, your 6 months is your new live offer. So there is always that risk, but practically speaking, if an employer was willing to put a certain amount of money on the table before, you can usually, get that retabled if your counter offer doesn't work out. But there's always, that risk that you might lose the money that's on the table. The other risk is that you might reach an impasse in negotiation. So you might counter at your 6 months, and Shopify says, absolutely not. We're not willing to give you anything more. And then you're in a position where you have to decide, okay, is this worth it for me to start, a lawsuit? Is it worth it for me to push this forward, given, like Andrew talked about, like how much money I'm going to spend to recuperate? So that cost, weighing the cost and the benefit. So typically we don't have to get into a position where you're thinking about suing or where you have to start a lawsuit. Most things do resolve amicably and off the record. But then I would say the main two risks is that you could lose the live offer that's on the table, and the second one is that you could be in a position where you have to sue, which is the only way to force an employer to pay out a certain amount that you think you're entitled to. But then we get into the whole all the issues that Andrew was just talking about with respect to costs and making sure that there's enough money in your file to warrant a lawsuit.
Yeah, that's really the biggest thing, right? Like if, let's say they're off by a month. We say you're entitled to a month more. If you make $60,000, it's not really worth the few $1,000s to get a lawyer to send a letter and try and improve it. My advice usually to people like that is like, look, yeah, I can do it, but you're paying me to get the exact same money that they might improve it by, and that's not really worth it. If you make $240,000 a year, all of a sudden an extra month is a lot more money, where spending a couple $1,000s for the chance of tens of thousands of dollars, even if they just improve it by a month, is maybe worth it to you. So I always just tell people it's about your risk tolerance. You are a little bit kind of going to the casino of like, okay, I'm going to spend X amount on my legal fees. I'm hoping to get, this amount. And that's where we just try and give you the best advice we can of, yeah, this is where we expect it would go. This is what we would expect it can cost, because your and my risk tolerance is probably very, very different. There are clients I see where I go, yeah, it's going to probably cost you $2,000 to $3,000, or sorry, $3,000 to $6,000, and there's a good chance you're entitled to, and they're going to, offer you another 20 to 40, and they go, absolutely, I'll do it. And then another client says, no, that's not worth it for me. I'd rather not risk that money. I can't. I don't have the money to risk it. And both answers are fine. It's ultimately about what's right for you in that situation. The other one is just back to Denise's first point about the first question is, I've been doing this now for 9-ish years. That has happened to me once in my career. And it was actually a case where I sent the person back to negotiate on their own. The employer pulled the offer off the table. I sent a nasty email to the employer and left a pretty nasty voicemail, basically on the lines of, what are you doing? They're trying to negotiate. They're negotiating in good faith. Why would you pull this offer off? I got a call from their lawyer that night, and we had settled the entire file the next morning. And the lawyer basically apologized to me on behalf of their client for being so silly. So, that's where Denise said the practical reality is, yes, it cancels the offer, but the odds of them holding firm on that stance and not at least offering what they paid before is pretty low. And that actually feeds nicely into, is it standard for the employer to reimburse employment fees? Lawyer fees. And the answer is sometimes. Probably more often than not, especially if we get an improvement to an offer, we are able to negotiate and get the legal fees paid in part, if not in whole. I think more than half the time. But if they don't, it just becomes part of the equation of, okay, you've improved your offer by $10,000, you've spent $3,000, you've netted $7,000. Can you live with that? Is that something you're okay with? And some people say yes, some people say no. And if the answer is no, then we push for more. But if the answer is yes, then you sign on the settlement and move on. And that's where it really comes down to what's right for you in your circumstance. The other thing in terms of marketably fair, I'd be careful with language like that and what is marketably fair, because most people actually are not aware of what is and isn't fair on termination. And it, again, it depends. If you are 64 with 8 years experience and you go to an employment lawyer or go to 5 employment lawyers, they're probably going to give you 5 different numbers in terms of what you're entitled to. And it's probably going to be somewhere in the range of like 14 to 16 months, because I can't remember if I said this, but older employees tend to get proportionately longer notice periods. They tend to get closer to 1.5 to even sometimes 2, not usually 2, but even sometimes 1.5 months per year of service. And so that's where it really, really depends on your situation, what is and is not fair. It depends on what your employment contract says. I know you have different employment contracts because I've seen different employment contracts from Shopify. So just be careful about blanket statements or people saying like, oh yeah, what they're offering is fair, because they may have offered, one person something that is fair, but that doesn't mean they offered you something that is fair. It all depends. And that feeds into are RSUs considered part of our comp? Shouldn't they be allowed not to be forfeited during the whole notice period? And this is one, I'm going to answer this as best I can, but I have not seen the RSU plan, at least not in a while. And that one is going to depend on what the plan says about vesting. I would expect it says something along the lines of RSUs will continue to vest during the statutory notice period, which is the week per year of service up to a maximum of 8 weeks. So any RSUs that vest during your statutory notice period, you're probably entitled to claim. You're also probably entitled to the extra week that is set out in your employment contract if you have that. In terms of what you're entitled to at common law, so let's just imagine you're entitled to 10 months at common law. Do you get all the RSUs that vest during that 10 months? I don't know because I need to look at the plan. I can't give you a good answer on that because I haven't seen the plan, and I've also seen RSU plans that are different for every employee because they revise them and they give it to one person when they were hired in 2013, and then they change it in 2015, and people hired after that all of a sudden have one that is legal while the earlier one was illegal. So it is really difficult for me to give you much more than that, but it is generally considered part of your comp. And I know one of the issues some of you are probably going to run into is, should it be part of your salary in terms of your common law notice damages? And that one is going to depend on what your T4 show, when you were exercising them. Were you exercising them every year? Have you been there for 9 years and every year you exercised a certain amount? And so you can sort of prove over time that this was a regular part of my income. I do know that Shopify markets its equity in RSUs as part of your total comp. I know that's something that they say, and that's probably going to work against them for anybody who's trying to advance that argument. But it's going to be a tough argument, and it's going to be one of the things that makes a lot of your terminations maybe a little trickier than other situations.
So the other question is about accommodation and what kind of documentation you should prepare if you had an accommodation. And I think this speaks to the broader issue of is the fact that you needed accommodation, is that somehow relevant to the termination? So in other words, has your termination been tainted by the fact that you had a disability for which you required an accommodation? And that is a very, very specific, kind of case by case issue that you need to really flesh out with a lawyer, because if you think that a disability was a factor in your termination, and that's really something that you should be answering that question with a lawyer, and by getting individualized legal advice, then you might be entitled to further damages that are beyond those termination entitlements we've been talking about. So then you're going into breaches of the Ontario Human Rights Code, and that gives way to general damages, which is a totally different bucket of money that you might be entitled to if there was a breach of the Human Rights Code. So the short answer is, if a disability came into play, or if the need for accommodation came into play, then it would be a good idea to seek legal advice, because that's something you want to flesh out with a lawyer.
Yeah, and just to add to that, it may not even be health or disability related. It may be family related. You had some accommodation because of your childcare obligations where you couldn't work past 4, and they've been accommodating that. And you're in a group of 20 people, and you're the only one with that kind of accommodation, and you were the one who was chosen. Or you made a sexual harassment complaint against your boss. You got moved into another group, and now you are again the only person in your group who has been terminated. It's not just disability, there's other sort of human rights grounds that could be at play, but again, this is where it's who knows what different situations are going on. We may have skipped one, which is it safe to say that any agreements that were ongoing at the time of termination, they still apply and are not dismissed due to the mass termination? So yeah, the fact that it's a mass termination does not nullify your employment contract. What it might have done, if we could actually prove that it was at least 10% of the workforce, is it would entitle you to the 16 weeks minimum. That's generally how their word is. It says you're going to get your Employment Standards Act minimums, and the Employment Standards Act says if it's a mass termination, you would get 16 weeks. But that is hard to prove, and that just reminds me, I think I saw a question somewhere in there about how do we prove if they're over or under 10%. And unfortunately, the only way to do it is probably to either ask them, which they will probably just deny it. And if they deny it and you're still not sure, is probably to sue them. If you sue somebody, you're entitled to disclosure and discovery, which just means the other side has to show all their cards and you have to show all your cards. But that would include being allowed to ask them how many people worked for you and how many people did you let go? And you could do the math from that, and they would be required under oath to provide an answer. But that's, I know, not a super satisfying answer, but that is that is how you would ultimately find out.
So the other question is about, how much time does the employer have to provide us with severance information? Pardon me, I haven't received any official documentation. So the severance information, so the amount that they're offering to pay you out, that would be included in your termination letter. So if you haven't received a termination letter, but you've been told, verbally that you're being let go, then you'll want to get a copy of that termination letter so you can understand what it is that they're offering you. There are specific timelines that employers have to pay you out your Employment Standards Act amounts, but you obviously want to have a little bit of certainty about, okay, so if you're terminating me, then I need to get a termination letter so I can understand what your offer is. And definitely, might speak to a broader issue if you're still unsure whether you form part of that group of people who've been terminated. You want to get some clarity on that, definitely, so you can figure out your next steps.
I see a lot of questions about the deadline. Is it enforceable? And I think there's a couple different variations of that question. So I'll answer that. So in terms of the ESA amounts, those are going to get paid out no matter what. Those have to be paid out. They will be paid. You can ignore the deadline for that. The second amount, or the second amount set out in the termination letter, is not legally enforceable. It's frankly not a thing other than being Shopify's first offer to settle your legal claims. Think of this as the moment you were fired, you were suddenly entitled to sue Shopify. Shopify is aware that you could sue them, and so they are making the first pass at negotiating a resolution. That's what that is. And so if the deadline passes and they haven't extended it, you cannot force them to pay you out on the terms of the second amount. So you can't sign it back to them on, let's say, I see August 9th as a date being listed. You can't sign it back on August 10th and say this is an enforceable contract. If you sign it back to them on August 8th, it's likely an enforceable contract and Shopify is required to pay it out. But this is where we get into the practical realities of, if you miss that deadline, if you make a counteroffer, if you ask questions, and Shopify says, no, you have till August 9th and you have to sign it. It's usually a sign that they're probably trying to pull a fast one and try to pressure you into signing it. And that's really a good sign that you probably shouldn't. Ask them for as much time as you need. Ask them for as much time to gather the documents that you need. Ask them for your employment contract if you need it. And if they're just refusing to provide you that, then that's a really good sign to maybe go get your own legal advice and maybe get a lawyer involved to write to them to say, we don't understand why you're being like this, other than it seems like you're trying to pull a fast one. So if the deadline expires, you will likely still get your Employment Standards Act amounts, because like I said, that is bad faith behavior for them not to pay it out. But the second amount set out in the contract, in the termination letter, is not enforceable, but practically speaking, they will reoffer it to you because they would be just absolutely silly not to. And, as indicated by the fact that I think they're firing less than 10% of the workforce just by a fraction, they're getting good legal advice. And so their legal advice would be, do not play hardball in that way, because all that does is it makes, your employees sue you, which you don't want, because that costs them money. They don't want that either. So I think I'm just reading through this first comment about it, because I think just want to make sure I didn't miss any questions in there.
Mm-hmm.
And sorry, the other thing I would say is, in mass terminations, I've actually found, generally the lack of information response and whatnot is more the product of them being inundated and just trying to catch up with the volume of, nearly 1,000 people being all let go at the same time, than it is some sort of bad faith tactic or anything like that. So if they're not getting back to you, not giving the extension, especially with a company like Shopify, I would actually probably think it's more an issue of understaffing. and trying to respond to people than it is one of them trying to, act in bad faith and whatnot. So I think you will likely be able to get that offer back on the table, but I can't guarantee it. But like I said, that's happened to me once. And I have, at least a call like this every week with somebody who's been let go, if not 2 or 3. So it's very, very rare that would happen. What aren't you allowed to share with a lawyer is also a good question. I'm sort of summarizing the next one. How much should we provide? You can share with a lawyer once we have been retained. So we have not been retained by any of you. We are just providing legal information, not legal advice. But if you were to retain us or another lawyer, it's covered by lawyer-client confidentiality, meaning you can share whatever with us. You're allowed to share everything. And we cannot disclose it to anyone. And that is not for our benefit, that's for yours. That's so that you can tell us the good and the bad of what happened at Shopify while you were there without it burning you. So, the example would be, you were fired after making a harassment complaint and you say, yeah, I made a harassment complaint against my boss, but also I said these, I swore at him in this meeting and yelled at him and slammed the door and walked away. What it does is it gives you that freedom to give us that bad information or the information that maybe you're worried about telling us so that we can give you an honest and accurate opinion. If you hid that information that, you swore at your boss or whatever it was, we might tell you, oh, wow, you have a slam dunk harassment case. Well, we would never speak in that strong of terms, but we'd send you down a road of, yeah, you should pursue that. But had we known that bad information, we might have said, well, hang on a sec, here's this risk you have to be aware of, which is you did not handle that conversation well. So you can share whatever it is you have or worried about sharing with us, short of you're about to commit some horrendous crime. But it comes up very rarely in the employment law world. So yeah, you're entitled to share whatever with us. The next one, Denise, I think is the question I already handled.
I'm just looking through them right now. A lot of the ones about the deadline. So someone was expressing confusion about the language that was used in the termination letters, because apparently the language says it's without cause termination, but then they're categorizing the reasons that that you've been terminated into 4 different categories. So I agree, that's really confusing because, why would you start talking about the reasons when it's without cause? But what you really need to pay attention to is, okay, are they saying it's without cause or with cause? Because they'll have to qualify your termination in that way. And the reasons that are given would, likely, not have they won't have any impact if it's a without cause termination. So generally, if I have another lawyer on the other side, I'm retained on the file and they start talking about all of the reasons that they were right in terminating my client and it's a without cause termination, I'll say to them, listen, this isn't at issue here. If you're alleging cause, then this is relevant. And if not, then let's just talk about entitlements. So it's probably just to provide further context. But again, if it says without cause, and that's how your that's how your situation is going to be treated.
Yeah, really, people in Ontario can be fired for virtually any reason under the sun, as long as it's not discriminatory. So as long as it's not based on race, gender, sex, disability, any of those types of grounds, religion. It can be, you wear yellow shoes and I don't like yellow shoes. That's fine, as long as they pay you out. That's the caveat. They have to pay you. They have to pay you under the Employment Standards Act, and they have to pay you your contractual or common law amounts. But as long as they do that, it's technically legal. Again, just to kind of pick up off on what Denise said, the one time that it can come a little bit relevant if it is one where they say, yeah, so without cause termination, but your performance was poor, and you're going, well, yeah, but I was struggling with a disability for the last 6 months that you were aware of, or something like that, that the reason is tainted. So they try and, again, disguise it as a without cause termination where there is a, tainted reason, or again, it's you made a harassment complaint or whatever it is. So something like that. In terms of contacting us for a chat, we'll drop our emails in the chat. You can contact us by email. Also, our website is just nelliganlaw.ca. On the homepage, there's a contact us button, and frankly, us or any of our colleagues would be more than happy to speak with any of you one-on-one. Denise, do you mind actually just writing our emails into the chat? I don't just so people have it at the bottom. Or you could just answer live to that question maybe, and then we'll talk with Hannah, who's our marketing person who helped organize all this with us today. And I think she can message anybody who registered possibly with our contact information, but nelliganlaw.ca is the website, and I'll have Denise figure out a way of putting our emails. We are lawyers. We are not good with Zoom tech, apparently. We're actually a Teams organization, so I think that's part of the problem. Who do I negotiate with? Usually you go back to the person who signed your letter. And if not, whoever the HR, usually the letter will say this person in HR is your point of contact. If you're having trouble getting a hold of them, you can always go back to whoever your direct report was or your team lead or whatever and say, I've been trying to reach out and they're not getting back to me. Who should I go to? But generally it's whoever signed your termination letter is who you would reach out to first. So the next question is, if Shopify were to roll out the new compensation model, seeing increased salaries being retro to July 1st, would the laid off employees be entitled to the increase in severance? Probably not, to be honest. But again, it would depend on what was told. If you were promised you would get it, maybe. It depends on how the promise was made and a bunch of other things. But generally, if they make a sort of retroactive adjustment to existing employees' salaries, you probably don't get to claim that. But it might depend. And I think I see the next question is very similar to that. I see tell them to check spam might be another tactic, I'm assuming, in terms of if you're getting a response, to check your spam folders. Sorry, I'm not sure what that one's in response to. To clarify, if it's a few thousand, it's probably not worth to chase it down. It probably not with a lawyer, frankly, if that is ultimately what you're entitled to, is like a couple extra $1,000. No. Is it worth you trying on your own? Maybe. That's often one of those where I'll tell people of like, yeah, don't hire me to do it, but you can send an email, see if they'll improve it by a couple months and respond to you. So it again, it depends, but it's probably not worth paying someone to do that, assuming you're not entitled to it. Oh, I see. Sorry, I see the question about the spam. So if by default we get a deadline extension because all the other emails landed in the spam folders and we don't have time to review with financial advisor in that short deadline, that is one to again just get the extension, ask for the extension, and don't let them put pressure on you if you need your advice. Like, get the advice, financial advice, legal advice, family advice. Talk to your partners, talk to your parents, whoever it is. Chat with them about what you want, what you need. These are sometimes family decisions that are being made, and we frequently have initial client meetings where the spouse or partner or whoever comes to the meeting. How much is a consult? It depends. Usually we tell people it's an hour and a half of our time. My rate is $320 an hour. So it's 320 times an hour and a half plus whatever amount of prep we have to do, which is usually 20 to 30 minutes max. However, we have given you at least 45 minutes to an hour of what we normally do in an initial meeting here. So odds are your consult would be significantly less expensive, because it really would. I wouldn't go through what the Employment Standards Acts are and what the common law is and what your contract is. I would review your contract in advance. Usually we get people to send a little summary of what happened to them if they do have specific circumstances. And then in like a half hour-ish, maybe a little bit longer, we talk about what you're individually entitled to. And it's kind of one of the reasons I wanted to do this is we can crowdsource, instead of charging, the bunch of you that may need your own advice, the 45 minutes to an hour. I'd rather just do it this way, give it up to all of you in this way, and then save you all the time and money, because it makes a lot more sense and it's a lot more practical to do it this way. Andrew's a funny ass dude. I appreciate that. Follow-up, we want to refrain from providing information in a consultation versus hiring them first. So when you consult with a lawyer, you are actually retaining us. We are your lawyer from the second we start giving you advice, even if it is an initial consultation. And so solicitor client's privilege applies from the second we have done our conflict check, confirmed that we can actually represent you. Anything you tell us is fine. And that's actually why we have a non-lawyer run the conflict check, is to make sure you don't give us advice accidentally that puts us in a conflict. Our intake clerk is named Wafa. She's wonderful. She's the one who gets all the information. And if it is, oh yeah, I made a harassment complaint against so-and-so, she will check to make sure we're not representing so-and-so. And if we're not, then you can give us the information. We can give you our initial opinion, and it's still protected by solicitor-client privilege. So I hope that answered that follow-up question. Denise, I'll let you take over. I've been going for a while.
Yeah, so for the link and the recording to the meeting, we're going to ask Hannah, who's our marketing person, to share that link. She's much better at doing the technology part of this, so she's going to share it, and then you can have access to this recording session for future reference. For the person who asked, they had offered me 2 weeks of severance pay. I signed the termination letter as it was before the group termination, and do I have any chance of fighting it for the 16 weeks? Well, that depends on whether or not you've signed a release. So if you've signed, that release usually is attached to the termination letter, and it says it's a lot of legalese for essentially, I'm giving you the 2 weeks in exchange. You're not going to, start a claim or a human rights issue or whatever. If you've signed that release, then you're going to, typically speaking, a person who signed a release will have a very hard time going back for more. But again, you want to you want to pay attention to your specific circumstances, because there are very limited circumstances where signing of a release was done, for example, under duress or something like that. So you again want to pay attention to those particulars of your situation. Shout out to the marketing manager. Yes, agreed. Hannah is awesome. And the last one was whether we're familiar with any European employment lawyers as well. And
Maybe.
I'm not sure about that. I'm not too sure about that.
Send me an email. We do have, there's kind of a network we have access to where we can source lawyers from other countries to put people in touch with them. So you can just flip me an email, and we have a contact person who's a part of that network, and probably find a referral depending on the country. It's going to depend, but we do have a sort of a network we can reach out to. So yeah, unless there's any other questions, that's I think everything we had. Denise, did you have anything else just before I cut it off?
No, I think that's pretty well it. Again, just going back to the other question about how do I get in touch with you guys? Well, I've left both Andrew and I's emails in the chat, but you can also go through all of our lawyer profiles if you wanna read a little bit about the lawyer. We have all of our videos and bios and stuff like that on our webpage, so you can peruse through that. And then again, Wafa, who is our intake clerk, she'll pick up the phone if you call our intake, and that's just the general number that you see on the website, and she can go through all those initial steps of doing the conflict and matching you with the lawyer of your choice and that kind of thing.
Yeah, and so I would encourage you all, we're recording the session. I would encourage you all to share it with any other colleagues or former colleagues who are in this boat. Shopify has gotten advice. They know what they're required to pay for the most part for each of you. And I really do strongly encourage everybody in this situation to get their own advice, even just general information, which is why we're recording this. One of the biggest challenges that we've both had throughout our careers is making sure people understand what their rights are when they've been let go or in the workplace. And we've learned that a lot of people just don't know, or what they know is not actually correct, which is why we do stuff like this. It's easier for us to do our jobs when people know what they're entitled to. So I would encourage you to share this with anybody who's in the boat, especially if they're just going to sign it back. Not frankly, they go to anyone. They don't need to come to us, but just to make sure they understand what they're signing away. Some of you are going to be signing deals that are probably in the hundreds of thousands of dollars. And, if you were getting a foundation repair, you'd probably make sure you got some advice on that first. And so if you're going to make, some kind of a transaction in that range, just make sure you're getting good advice and know that what you're signing is fair. So you're not kind of a year later going, I should have done something. Then you go get legal advice, and the legal advice is you should have come to me a year ago because you signed a release and there's nothing we can do. So, thank you all for taking the time. Again, we're I'm sorry you're in this boat. But it will pass. The best part of this job is usually when I get emails from people 6 to 12 months later telling me about how great their next job is, and that is frequent that I get those emails. So thank you all very much, and don't hesitate to reach out to us if there's anything we can do to help. So I will end it there. Thank you.